Hello, and welcome to Williams Mullins' Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets, such as patents, trademarks, copyrights, and trade secrets. I'm your host, Carmelle Alipio, and today I'll be joined by Courtney Reigel, my colleague and fellow associate in our intellectual property and data protection and cybersecurity practice groups here at Williams Mullen to discuss FTC privacy enforcement. Hey, Courtney, how are you today?
Thanks, Carmelle. I'm doing well. I'm looking forward to discussing recent trends in the Federal Trade Commission's privacy enforcement efforts. I know you and I have spent some time tracking some of the state data privacy laws that have been getting a lot of attention over the last few years, and with good reason. But today, I think it will be helpful to remind listeners that even though there isn't a comprehensive data privacy law similar to, for example, the CCPA or Virginia's Consumer Data Protection Act yet, that the FTC does have authority to enforce certain violations relating to consumer privacy. Shortly, Carmelle is going to give listeners some details on recent FTC enforcement cases, but first I wanted to briefly discuss the scope of the FTC's enforcement authority with regard to data privacy and security. When a business says it will safeguard its customers' personal information, such as in its privacy policy or other terms of service, the FTC can and does take action as a federal law enforcement agency to ensure that the business honors the promises it's making to consumers. The FTC has brought legal actions against businesses that, for example, have violated consumers' privacy rights by maybe not properly disclosing how the business is using or selling consumers' personal information. The FTC has also brought legal actions against businesses that fail to maintain security for sensitive consumer information or cause substantial consumer injury due to security breaches that could have been and should have been avoided if reasonable security measures were in place. In many cases, the FTC's authority to charge businesses with these types of violations comes from Section 5 of the FTC Act, which bars unfair and deceptive acts and practices in or affecting commerce. But in addition to the FTC Act, the FTC also enforces other federal laws relating to consumers' privacy and security, such as the Children's Online Privacy Protection Act, sometimes referred to as COPPA. In terms of recent enforcement trends, it's worth noting that COPPA enforcement and protecting children's information online has been a big priority lately for the FTC. There's definitely an uptick in businesses' collection of children's personal information online during the pandemic. A lot of educational instruction and resources were being pushed online, and this caused the FTC to issue warning language that businesses need to be careful about surveilling children or forcing them to provide certain personal information with or without parental consent just to be able to do their schoolwork online. I would also note that not obtaining parental consent when required is also a big no-no and somewhere that the FTC may step in. A few other areas we've seen the FTC focus on in recent enforcement actions includes targeted advertising and disclosing that the business is using customers' personal information for that purpose, when businesses impermissibly sell personal information, and also augmented and virtual reality game regulation or other means of collecting information from customers for facial recognition purposes or other biometric data. With that, I will mention that Carmelle recently attended the International Association of Privacy Professionals Global Privacy Summit, and I know she has a lot of really interesting information to share with us today, including a few details from a recent FTC enforcement case, as well as some high-level advice and notes on trends for fellow privacy professionals and business alike.
Thanks, Courtney. The IAPP's Global Privacy Summit was in DC this year, and it was not only interesting, but also super informative. I really enjoyed meeting and learning from so many privacy experts. Not only did I have an opportunity to hear from folks in the industry, but I was also able to sit in a commissioner of the FTC's keynote speech, Alvaro Bedoya, and I also attended some panel discussions with former and current FTC attorneys. As you mentioned, the digital health space is one that the FTC has been honing in on as of late. We've seen this a lot recently. For example, in the Kochava case, the Kerbo Weight Watchers matter, and the GoodRx matter. But today, let's focus on the recent FTC enforcement action against BetterHelp. Last month, the FTC announced a consent decree with BetterHelp, an online counseling service that matched up users with contracted licensed therapists. Users on BetterHelp communicate with their therapists via video, text message, live chat, and by telephone call. But during the sign up and intake stage, BetterHelp represented to its consumers that their information would stay private between themselves and their counselor. Brought under Section 5 of the FTC Act for unfair and deceptive practices, the FTC alleged that from 2013 to 2020, BetterHelp broke this privacy promise by monetizing consumers' health information to target them and others to use BetterHelp services. And from 2018 to 2020, BetterHelp revealed its consumers' sensitive data with third parties for advertising purposes, including Facebook, Pinterest, and Snapchat. These third parties were able to use consumer information for their own research and product development. The FTC also alleged that BetterHelp prominently displayed a seal that it was in compliance with HIPAA, the Health Insurance Portability and Accountability Act of 1996. However, no government agency or third party had reviewed BetterHelp's information security and privacy practices for HIPAA compliance or determined that BetterHelp was actually HIPAA compliant. The FTC also alleged that BetterHelp failed to employ reasonable measures to safeguard the information it collected, including a failure to train its employees on how to protect consumer information when using it for advertising, provide proper notice as to the collection, use, and disclosure of consumer health information, and a failure to limit third-party use of consumer information, and they relied on stock contracts and terms. The consent decree is a proposed order that will require BetterHelp to pay $7.8 million that will be used to provide partial refunds to people who signed up and paid for BetterHelp services between August 1st, 2017 and December 31st, 2020. BetterHelp will also be prohibited from sharing consumers' health data for advertising or sharing their personal information for retargeting, which means serving ads to consumers who had visited BetterHelp's site or used its app. And BetterHelp will be limited from data sharing in the future. This is a pretty typical result from an FTC enforcement action relating to the privacy and data security space. While under the consent decree, BetterHelp did not admit or deny any of the FTC's allegations, the FTC has made evident that this matter with BetterHelp is one that they are planning to use as an example, as the consent decree also included a requirement for BetterHelp to obtain express affirmative consent, also known as opt-in consent, which is not a requirement currently present for most entities.
Thanks, Carmelle. I think discussing these types of enforcement cases really helps to highlight for our listeners what the FTC is really considering in terms of when they're going to bring an enforcement action, and also what these enforcement actions are going to end up with. $7.8 million is significant, and businesses really need to be more aware of their privacy practices. So with that, to just complete our discussion today, what advice or trends did you want to mention to listeners?
So the FTC's authority in this space really stems from the FTC Act in Section 5, but we've noticed that the consent decrees that are issued are really informative as to what specific action items businesses can take. The three trends that I think businesses can focus on going forward include data minimization, consumer notice, and redress. So for data minimization, that's limiting the amount of data that you collect for the purposes that require consumer data, limiting the length of time that you possess and control that consumer data. And not only does that alleviate the number of consumers at risk, potentially, it also makes data security much more manageable. And you can establish a robust record of your data minimization practices in the event the FTC comes knocking on your door. Vulnerable groups such as children and sensitive personal data like health data are more likely to be subject to an FTC enforcement action. As we saw in the BetterHelp consent decree, there's a potential for a move toward opting in rather than opting out. Now, while FTC guidance is mostly unofficial and consent decrees do not fall under FTC rulemaking authority until Congress passes a federal privacy law, the FTC won't back off from its aggressive enforcement actions. Turning to consumer notice, businesses should carefully review their privacy policy and ask themselves, are they actually operating within the limits of the privacy notice? Are they disclosing third-party sharing methods accurately to consumers? Do companies have an agreement with those third parties to ensure that they are operating within those same limits? And finally, for redress, we've seen the FTC seek redress in the millions of dollars as of late in federal district courts for consumer injury caused by the conduct at issue. The FTC must demonstrate in these cases, brought under Section 19 of the FTC Act, whether a reasonable person would have known under the circumstances that the conduct was dishonest or fraudulent. And companies can avoid dishonesty or fraudulent allegations against them by confirming that the notices and information that they're putting out there and providing to consumers is not only accurate, but updated.
Thanks, Carmelle. I think that's a good point to remind businesses that your privacy notices that were drafted 5-10 years ago likely need another look, and to consider the trends that we mentioned today when you're updating those privacy policies and notices. And that will wrap our discussion on FTC privacy updates today. I'd like to thank Carmelle for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast, as well as legal alerts. Please be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.